Hello guys, welcome to our channel Legal Nexus. Today we are going to discuss about general defense. The defendant is generally liable to pay damages to the plaintiff for the tort committed by him. If the plaintiff is able to prove that wrong committed by the defendant comes well within the essentials and scope of the tort. General defense in tort law allows a defendant to avoid liabilities for a tortious act by providing a legal justification for their actions. The following defenses are available to the defendant. Voluntary non-fit injuria. Voluntary non-fit injuria means where there is a consent, there is no injury. An act is not actionable as tort at the instance of any person who has expressly or impliedly consented to it. The principle is based on justice and good consents. One of the important cases related to voluntary non-fit injury, Hall versus Brookland Auto Racing Club. Hall was a spectator in a car race. Two cars collided and Hall was injured in collision. In an action for damage, since he had given implied consent to run the race, he was not entitled to receive damages. Essentials of voluntary non-fit injury. There must be an express or implied consent to face the risk. The consent must be free. Since a minor cannot give valid consent, the doctrine is not applicable to minors. The injury or loss must not be caused by willful intention of the defendant. The defendant should not be negligent. If he is negligent, this doctrine is not applicable. This doctrine is not applicable for illegal acts. This maxim is not applicable to rescue cases or cases of saving persons in danger. Consent obtained by fraud. Here, the defendant must prove that the plaintiff's consent was voluntary or free consent obtained by fraud is not valid consent, and hence a consent obtained by fraud cannot be a defense for the defendant. Inevitable accident. It is an accident which could not be avoided even after the exercise of ordinary care and caution of the defendant. In simple terms, it is an accident which cannot be avoided despite the exercise of ordinary care and caution. If the injury or loss is due to unavoidable circumstances beyond the human control, then such injuries of a person cannot be sued under the tort of negligence. Stanley versus Paul. The plaintiff and defendant went for peasant shooting. The defendant fired at a peasant, but the shot from his gun bounced off on oak tree and injured the plaintiff. The court held that the injury was due to inevitable accident and hence the defendant was not liable. Brown versus Kendall. The defendant accidentally hit the eye of the plaintiff when he was beating his dogs, which were fighting with one another. The plaintiff could not recover damages. Act of God. It closely resembles the defense of inevitable accident. The loss or injury is due to the working of natural sources beyond the power of any human beings and which could not be reasonably expected. Act of God is an accident which is due to natural causes of directly and exclusively without any human interventions, and that could not be prevented or averted by the exercise of human or caution and control. Some examples of act of God is storm, tempest, lightning, extraordinary fall of rain, high tide, surf forest, etc. Nicholas versus Marshland is one of the important cases related to act of God. The defendant was the owner of some pool on his land. The pools and their letouts were constructed without any negligence. A heavy and violent storm broke down the embankments and water flow out and damage was caused. Since the water has escaped only due to act of God beyond any human control, the court held that the defendant was not liable. Necessity. This defense stands for any act causing damages if done under necessity to prevent a greater evil, is not actionable, even though harm was caused intentionally. The basis for accepting necessity as a defense is maintenance of public good and self-protection. Example, act done in exercise of duty of military authority in times of war. Cobb versus Sharp. The defendant trespassed on the plaintiff's land to prevent spreading of fire. The court held that the defendant was not liable because he acted under necessity. Mistake. Here there is an admission that the act and its consequences were intended, but the defendant acted under an erroneous belief formed on reasonable ground. Mistake can be two types: mistake of law, mistake of fact. Mistake of law. Ignorantia juris. It is not excusable in crimes and tort. Ignorantia juris non excusat is the maxim ignorance of law, or mistake of law is no excuse. Mistake of fact. This is excused under PNS, but not so in tort. So even if a person has acted under a mistake of fact, but his act caused harm to another, then he is liable to pay compensation for such harm caused. Morrison versus Ritchie. A newspaper proprietor anonymously published that the plaintiff has given birth to twins, where she got married only a month before. The court held that the proprietor was liable even though he had acted under mistake of fact. Private defense. Private defense is the right of every person to defend his own person or property and that of his near relative. If the plaintiff attacks the defendant, he can defend himself against such attack. The plaintiff may be a competent or an incompetent person. Example, lunatic private defense is a self-help. Essentials. The force applied must be proportionate to harm anticipated. Reasonable step can be taken by a person to protect his property. Morris versus Nugent. When the defendant was passing by plaintiff's house, the plaintiff's dog ran and tore the defendant's clothes, covering his ankle. The defendant raised his gun to shoot the dog, but the dog ran away. Even then, the defendant did not stop and he shot the dog dead, even while it was running away. The court held that the defendant had used excess force and hence liable to compensate the plaintiff. Plaintiff the wrongdoer. One of the principles of law of contract is that a court does not help a person whose course of action is tainted with an immoral or illegal act. It is known by the maxim ex turpi causa non orito actio, which means from an immoral cause no legal action arises. In law of tort, it is doubtful whether the defendant can take the defense of immoral illegal act of the part of plaintiff to escape from the liabilities of paying compensation for his wrongful act to the plaintiff. Bird versus Woolbrook. The House of Lords held that the plaintiff, though a trespasser over the defendant's land, was entitled to claim compensation for injuries sustained by him due to a gunshot kept in the defendant's garden without the notice. Statutory authority. If any act is done as per the authority and direction given under the statute, and thereby if any damage or loss result to the plaintiff by such an act, then no action can lie against the person doing such act. In other words, if there had been no such statute, then such act would be actionable as tort. Thus, the statute gives complete protection to the person doing the act, and plaintiff is entitled to only such compensation, if any, as is provided under the statute. The statute gives immunity to the executors against both direct injury or loss and also the incidental harms. Harmsworth Railway Company versus Brand. The plaintiff property situated adjoining the railway line due to the noise, vibration and smoke emitted by the running of trains on the railway line constructed under the statutory power, the value of plaintiff's property had considerably reduced. In this case, court held that since the damage caused was incidental to running of trains authorized by the statute, no action could lie. Statutory authority can be classified into two: absolute statutory authority and conditional statutory authority. Absolute statutory authority means the statute gives absolute authority for doing an act which may be cause harm or nuisance, but it is not actionable and there is no liability for the act. In construction of railway line, even there is nuisance to a private land, it is not actionable. Conditional statutory authority. In this case, the statute gives conditional statutory for doing an act. It means that the act authorized can be done only if no harm or nuisance is caused. Such conditional authority may be express or implied.